I'm going to talk to you this afternoon about dismissal of proceedings for culpable delay following the decision of the Supreme Court in Kirwan and Connors. And I'll give you a brief outline of what I intend to say before I go into it. And first of all, I'm going to give you just a short description of the scope of this presentation. I'm going to talk to you then about the pre-existing law and practice, so the context into which Kirwan arrives. I'm going to talk to you about the decision itself then. I'll sketch the facts briefly. I'll give you a procedural outline. I'll give you a thumbnail sketch of the four judgments of the Supreme Court in the case. I'll then get into the meat of it a little bit, discussing key passages and highlighting the approach taken. There, I'll focus on the majority approach and primarily on the decision of the Chief Justice. Having highlighted those key passages, then I will go through some notable features of the new approach. And then if there are any questions, I'd be happy to take those. So, beginning with the scope of the presentation, and you'll all be familiar with the two overlapping lines of jurisprudence that we contend with in this area. First of all, there's the Primor and Stokes-Kennedy-Crowley line of jurisprudence, also referred to as the Rainsford line. And that concerns delay that is culpable, so delay that is inordinate and inexcusable. And secondly, we have the O'Donnell and Merrick line of jurisprudence, and that concerns delay that, irrespective of its cause, is such as to put justice to the hazard to such an extent that it would be an abrogation of basic fairness to allow a trial to go ahead. I should pause there to say that I've sent Ian my slides which have all of these references in them, so there's no need to take notes as you're going along. Obviously, feel free to do so nonetheless. The distinction between those two lines of jurisprudence. So, you can be free with that if you're at the old moments, 3, 2, and 3 here. Yeah, it's still broadly exchanged. Yeah. And
sorry, can you put your cameras on mute? Sorry, can you put your microphones on mute, everybody?
All the stages.
Right, okay.
Okay.
Okay, Garvan.
Great, I'll continue then. So the distinction between the two lines hasn't always or wasn't always clear, and the two are still said to overlap, but they have become clearer in more recent years. And so what we're concerned with today is only the first of those two. So applications to dismiss proceedings in a case of culpable delay. The Primor line of jurisprudence, if you like. And again, as you'll all be familiar with, Primor brings what is often called in the judgments a three-step analysis. First question in the first step is to ask whether there's been inordinate delay. Next, the court asks whether there's been inexcusable delay. And thirdly, then, there's a broad-ranging analysis as to the balance of justice. Now, that in fact might better be seen as a two-step inquiry, and I'll come back to why this is important, but the first step might be seen as a kind of a threshold inquiry into the nature of the delay in the case concerned. Is it inordinate and inexcusable? And once that threshold inquiry is passed, there's then an inquiry into the balance of justice. And the significance of that conception of the Primor power to dismiss is that in truth, the presence or absence of culpable delay was rarely the determining factor in a case, and rarely the battleground on which the applications were fought, for the obvious reason that applications were really only brought where there was some confidence as to the presence of both inordinacy of delay and that it was inexcusable. And so, as I say, the contest generally came to focus on the balance of justice. And in all three or all two, depending on your view, the burden of proof lay on the defendant. And ultimately, the defendant found itself having to demonstrate that the balance of justice weighed in favour of dismissal, and that became the primary battleground in most of these applications. One effect of that, and something focused on by the Supreme Court in Kirwan, was that because the debate was about the balance of justice, the cases really didn't focus on the problem of delay in and of itself. And so the problem of delay in and of itself was often passed over as a box that had to be ticked before you got on to the meat of the application. And when it came to the meat of that application in the debates on balance of justice, typically they boiled down to three areas. First of all, the question of whether there was prejudice to the defendant, and secondly, the question of the defendant's conduct, and thirdly, the likely nature of the evidence. So the question was raised as to whether it would be a documents case or one that depended on oral testimony. So they were the primary areas of contest around in the area of prejudice. In the area of balance of justice. And dealing with the first of those, and what's sometimes called, or was called, the major element of the balance of justice, prejudice to the defendant. The cases over the years had described prejudice in different terms, including real prejudice, substantial prejudice, significant prejudice, moderate prejudice, marginal prejudice, and then presumed or assumed prejudice. We also had the ideas of concrete prejudice or general prejudice. And the forms of prejudice were described as being open-ended, so that the obvious and primary form of prejudice perhaps was a fair trial prejudice, which related to the ability of the court fairly to hear the matter, given the time that had passed since the occurrence of the underlying events. But that wasn't the only one, and in cases like Celtic Ceramics back in the early 90s, the idea of professional reputation coming in as a form of prejudice came to the fore. Also, there have been instances more recently in which financial prejudice, for example, in the form of increased insurance premium for professionals, that was a form of prejudice relied upon. I think in the Gibbons and N6 decision, which you'll be familiar with from a few years ago in the Court of Appeal, the form of prejudice there was that the defendant couldn't wind itself up. It was a special purpose vehicle that had been formed for a particular project, and the litigation was preventing its orderly wind down. Then there was the question of the defendant's dilemma in relation to prejudice. And this was identified in stark terms by Mr. Justice Clark, as he then was, in Rogers and Michelin Tire back 20 years ago now, in 2005, where he noted that a defendant bringing an application such as this inevitably faced uncertainty as to whether that application would succeed or not, and had to be careful as to how much he or she was prepared to say on affidavit about the prejudice that they were suffering, and in particular about, for example, failing memories among their witnesses. Because obviously, if the application proved unsuccessful and their witnesses had committed themselves on affidavit to a position that their memories, in fact, were now unreliable, that was going to prejudice them when it came to the trial. And so Mr. Justice Clark said there that it was acceptable for defendants to rely on general prejudice. That was a proposition that wasn't always, certainly in my experience, accepted by High Court judges. And you had a range of different attitudes among judges, as is common and will always be the case, I suppose. But it meant that the question of prejudice was quite an indeterminate one when you came to face it. Now, looking at the primal regime more generally, some key features involved, first of all, an emphasis on the far-reaching nature of a dismissal of proceedings, and on the connection between that and the constitutional right to litigate. And this is an issue that arose with, came to the fore in Kirwan, and I'll come back to that in due course. It became the subject of a dissent by Mr. Justice Collins from the majority decision. But as the Chief Justice describes it in Kirwan, this emphasis on the far-reaching nature of dismissal immediately placed a defendant bringing an application for dismissal on the back foot. They had an uphill struggle to convince a court to dismiss. Secondly, is the conception in Primor, and going all the way back to Dowd and the early Irish jurisprudence, that responsibility for case progression lies not just with the plaintiff, but also with the defendant. And so in Primor, it said that litigation is a two-party operation. In Dowd, back in the 70s, Chief Justice O'Dowd said that it wasn't leaving sleeping dogs lie might be a calculation that a defendant might make, but it wasn't calculated to achieve the ends of justice. And so there was a clear understanding in the decisions that both plaintiff and defendant had a responsibility. And that had implications in terms of the balance of justice and the conduct of the defendant. And there was uncertainty about the conduct of the defendant in the authorities. And again, that made for potentially subjective approaches by different judges who would lay greater or lesser emphasis on that responsibility in the defendant's hands. Next, and again a feature noted by several of the judges in Kirwan, is the basic problem of indeterminacy. So there's, first of all, you have varying fact patterns presented in these applications as to a potentially long duration procedural history, varying fact patterns as to the origin of the litigation, the issues in the litigation, how the evidence was going to be adduced and unfolded at trial. Next, you had questions as to inordinacy and inexcusability. What was inordinate delay? And again, you had a very fact-specific approach by the courts where they were disinclined to take any particular benchmark and simply say, this is inordinate. It was all highly fact-specific, as Mr. Justice Collins noted in the Cave Projects case a number of years ago. And the same applied in relation to the question of whether the delay was excusable. So that, again, there was a lot of room for manoeuvre and room for a subjective approach on the part of judges as they came to decide these cases. And in addition to that, then you had the factors going to the balance of justice, which, as described by the Chief Justice in Kirwan, as factors that really were less of measurement than of assessment. And the same might be said in relation to the inordinacy of delay, that it was never intended to be a matter of adding up small periods of time to come to a mathematical formula. But on the other hand, that generalized approach gave rise to indeterminacy in the approach of the courts. And so both Mr. Justice Hogan and Chief Justice O'Donnell noted that that gave rise to the potential for subjective and contestable conclusions. And so to hard-fought applications before the High Court, and the potential also for appeals to the Court of Appeal. And that had the ironic effect, as noted in the judgments in Kirwan, that applications to strike out for delay often themselves were the source of further delay in cases. And Kirwan isn't necessarily a bad example of that, in the sense that the underlying facts in Kirwan, I'll come back to these, dated back to 2005-06. The proceedings were begun in 2013, and the applications to strike out were brought in 2018. The High Court judgment is given in 2019. There's delay with COVID and various things to bring it before the Court of Appeal. It gives its decision, I think, from memory, I'll come back to in 2023. And then we had the Supreme Court giving its decision in 2025. So you have a significant extension of time dealing simply with the application to dismiss for want of prosecution. And that in itself is unattractive. Another feature of the Primo regime, as I've discussed, was that it removed the essential focus from the delay itself or from the plaintiff's inaction itself and took it into these various debates about the balance of justice and what should be happening or should not be happening and who should have done what and all of that. And finally, another factor in Primo, obviously, that you'll all be familiar with from the defence perspective, was that the defendant bore the entire burden of proof, even though, at least in relation to one question, the excusability of the delay, that was always something that a defendant had difficulty making a point as to, because they didn't know what excuses were being raised. And typically, no attempt to excuse the delay had been made when the application was brought. So to come then to Kirwan and Connors and the facts in outline, they're a bit tortured, but I'll try and bring you through them. I should say I appeared for the solicitor defendants in Kirwan and Connors with Daniel Sims, BL. So I have some background knowledge, but this is based on the judgments which do outline the facts. So again, no need to get too tied up in the detail here. It's all written down. So in 2005/6, Mr. Kirwan enters into negotiations with a Mr. Buttle, with Mr. Buttle seeking to acquire property, yards and buildings in Wexford town for redevelopment from Mr. Kirwan. And ultimately a deal is done in 2006 and it's papered at that point. And essentially what it involves is an agreement by Mr. Buttle to buy this development property from Mr. Kirwan, subject to planning permission, for cash and non-cash consideration to the value of 4 million in aggregate. And a particular feature of the arrangement reached was that the buyer advanced to the seller a loan of €1 million pending the getting of planning permission and then completion of the transaction. So on day one, Mr. Kirwan got €1 million or thereabouts from Mr. Buttle, and the idea was that that would wash out at completion of the deal. Of course, completion of the deal never happened. In 2008, with the general economic collapse, it was abandoned. In 2011, Mr. Buttle, or his assignee, in fact, he had by then assigned the receivable under that loan to a company called Philbeck, and Philbeck sued for the return of that 1 million, and it got judgment in the office in 2012 against Mr. Kirwan. In 2012, Mr. Kirwan, sorry, that's the first set of proceedings, 2011. They involve Mr. Kirwan and Mr. Buttle, or Philbeck, Mr. Buttle's company. In 2012, Mr. Kirwan applied to have the judgment against him set aside. And separately, he sued Mr. Buttle for what he alleged was the outstanding purchase money of circa 3 million. And at the same time, Mr. Buttle applied to have Mr. Kirwan's new 2012 proceedings struck out as bound to fail. So now we have two sets of proceedings, and we have two applications. First of all, to set aside the 2011 judgment, and secondly, to have the 2012 proceedings struck out. In 2013, both of those applications to dismiss the 2012 proceedings and to set aside the judgment were coming on for hearing. And Mr. Kirwan secured an adjournment of both in order to prosecute proceedings that he had begun in mid-2013. And these proceedings were begun against Mr. Buttle, his company, various individuals connected with Mr. Buttle, and also against the solicitors who had been involved in the underlying property transaction. Mr. Kirwan got that adjournment in late 2013, and so effectively got a stay on creditor action against him. And once he had delivered his statement of claim in the 2013 proceedings, he did nothing further to advance them. There was controversy as to whether or not he had delivered notice for particulars, but ultimately that proved unavailing to Mr. Kirwan. In 2018, then, both the solicitor defendants and the Buttle defendants applied to dismiss the actions under the court's inherent jurisdiction on the basis of culpable delay. And in that application, the solicitor defendants pointed to two elements of prejudice. And I'm sure you'll all be familiar with the frequent difficulty of identifying particular forms of prejudice. Here, the solicitor defendants pointed to the retirement from their firm of a key individual, Miss Connors, the first defendant. And so not only was she was still around and ultimately could have given evidence, but she'd stopped having any connection from day to day with work of the kind that these proceedings were concerned with since 2008, and we were now in 2018. And the solicitor defendants said that this prejudiced them. They secondly said that they suffered prejudice as professionals in a small business community in Wexford. The Buttle defendants, by way of prejudice, pointed to the stymieing of enforcement of their judgment for $1 million against Mr. Kirwan, which they got in their 2011 proceedings. Mr. Kirwan, in turn, sought belatedly, really only in the days when the action came on for hearing before Mr. Justice Meenan in the High Court. He sought to explain his delay by reference to the disputed late release of his file by the solicitors, and that was disputed by the solicitors and ultimately came to nothing for Mr. Kirwan. A notice for particulars that he had disputedly issued and which he said, again disputedly, had been ignored. And then for the first time on appeal before the Court of Appeal, he sought to rely on the claim that the solicitors were pursuing him for fees in separate litigation. In the High Court, to give a brief outline of the procedural history, Mr. Justice Meenan gave judgment in 2019. The Court of Appeal affirmed that in 2023. And then Mr. Kirwan, who had been self-represented in the High Court, represented by solicitors and counsel before the Court of Appeal, again became self-represented after the appeal judgment had been delivered, and he applied for leave to appeal to the Supreme Court. And the Supreme Court gave leave in March of 2023 explicitly on the basis that Primor was due a review. So there wasn't any identification of any particular question arising from the judgment which was given by Ms. Justice Power for the Court of Appeal. Rather, it was just that the overall question of Primor was due a review. The appeal came on for hearing in April of 2024 before a 5-judge panel of the Supreme Court, and it later decided to reopen the appeal for re-argument before an extended 7-judge panel and invited the Attorney General to participate, which he did, and that re-argument was heard on the 12th of November, I think, or in November of last year, and judgments obviously have just come out. There are 4 judgments of the court The first, and I think what is likely in terms of the reference point to become the primary judgment, is that of the Chief Justice, with whom Ms. Justice Dunn, Mr. Justice Charlton, Ms. Justice O'Malley and Mr. Justice Hogan all agreed. There's a lengthy judgment by Mr. Justice Hogan analysing the fact pattern, the various decisions in the courts below, and also the history of the development of the primor jurisdiction. And Mr. Chief Justice O'Donnell, Ms. Justice Dunn, Mr. Justice Charlton, Ms. Justice O'Malley all agreed with that judgment of Mr. Justice Hogan. There are some differences of emphasis between the Chief Justice decision and that of Mr. Justice Hogan, and ultimately the Chief Justice does point to a key passage of his judgment, to which I'll come back, as setting out the approach to be taken in these cases in future. There are two other judgments. Mr. Justice Murray dissented as to the source of the power to dismiss proceedings. He took the view that the Supreme Court had taken a wrong step in primor when it went down the road of attributing this power or jurisdiction to the inherent jurisdiction of the High Court. He noted that in doing that, the Supreme Court in primor was following English cases, Burkett and James being the leading case from the House of Lords. But critically, Mr. Justice Murray said what the Supreme Court missed in primor was that the English rules of court did not contain an equivalent of Order 122 Rule 11, which, as you'll be aware, enables an application to be brought for the dismissal of proceedings where there has been no step taken for 2 years or more. It's also the rule that governs notices of intention to proceed. And it also goes on to say that the court has power generally on the making of an application to dismiss, to make case management directions and the like. Something that I have to confess had been overlooked generally, I think, but certainly in my case, the focus was very much on the dismissal. But then people were mainly relying on the inherent jurisdiction, I think it's fair to say. So Mr. Justice Murray dissents on the question of the source of the power, and he says it's referable exclusively to Order 122. And that, in his view, meant that the conditions of Order 122 Rule 11 had to be met. But with that said, he goes on to adopt an essentially similar position to the majority in relation to the approach of the court, and indeed the ultimate approach as it's set out in the judgment of the Chief Justice borrows significantly from Mr. Justice Murray, albeit that the Chief Justice relies on the inherent jurisdiction and so doesn't address himself to the conditions set out in Order 122 Rule 11. Mr. Justice Collins dissented on the questions of prejudice and on the question of the defendant's role. So his concern was more with a situation where, notwithstanding that there had been delay, it was still possible for there to be a fair trial. And he was concerned that a case could be struck out in those circumstances where, in truth, the defendant couldn't point to any real or concrete prejudice, and separately the defendant's role in the proceedings might be relied upon to say that the defendant should be bound to go to trial. So they were his concerns, but he didn't succeed in bringing any of his fellows, including Mr. Justice Murray, with him on those concerns. And so his judgment stands in isolation, both in terms of the general approach to be taken and those two specific questions of prejudice and the defendant's role. The dissents notwithstanding, there was universal consensus on a number of things, as the Chief Justice notes. First of all, that Primor isn't achieving its objectives, or wasn't achieving its objectives. Secondly, that a new rule of court was highly desirable. And thirdly, that both the High Court and the Court of Appeal had been correct to dismiss in this particular case. So all 7 judges of the expanded panel of the Supreme Court dismissed the case. And interestingly, while Mr. Justice Collins laid emphasis on prejudice, he was also inclined to accept the prejudice put forward by the solicitor defendants that I've outlined to you, particularly in relation to the retirement in 2008 of Miss Connors, whereas judges in the majority were inclined to say that that didn't come up to the level of specific prejudice, while it was something that was assisting the application, it wasn't determinative of it. So they're the 4 judgments in outline. I'm going to focus now principally, as I said, on the majority judgments, and really principally on the judgment of the Chief Justice. That's not to take from any of the other judgments, and they all are readable and reward reading. So to come to some of the key passages, and these again are all noted in the slides with the paragraph referencing, so you'll be able to pick all of these up. From the judgment then of the Chief Justice, an early point that he makes is that while the courts must hold the scales equally between plaintiff and defendant, that does not mean that they are to be treated as the same when they are not. They are not co-adventurers in litigation. The essential structure involves a plaintiff invoking the jurisdiction of the court to summon a defendant, requiring them to answer. The plaintiff has an interest in and responsibility for bringing the claim to trial. The same cannot be said of a defendant. And Mr. Justice Murray says something to very similar effect in his own judgment. The Chief Justice continued to say that a well-known feature of litigation is that many more actions are commenced than proceeded with. A defendant is not required to spend time, energy, and resources on a claim which may never be heard, and defendants should not be criticised for doing no more than is required to respond to a claim. Unless a defendant's conduct reaches the level of acquiescence or positive encouragement of the plaintiff's inactivity, it is not a valid answer to the plaintiff's inactivity. He goes on to say that delay in and of itself is inimical to the just resolution of disputes. And he notes also the practical realities that bring pressure on defendants to settle in circumstances where they lose an application such as this. And in fact, that is, it brings to mind the comments of the Chief Justice in the Merck Sharp and Doman Clonmel healthcare case, which dealt with injunctions, as you'll be aware, where again he was concerned with the procedural law surrounding injunctions in that case, allowing a plaintiff to turn a very poor case into a very good negotiating lever by getting an interlocutory injunction while only having to meet a very low standard in terms of the strength of their case. So that there's an obvious, it seems to me, preoccupation in the mind of the Chief Justice with the reality of litigation. Moving on then, at paragraph 23 of his decision, he identified the weaknesses in the Primor test. Firstly, in that it involved a balance of a number of factors, giving rise to a necessarily subjective and contestable conclusion, resulting in lengthy hearings and appeals. I've noted that already. Second, it proceeded on the assumption that the jurisdiction was an interference with the right of access to court, and which required a particularly weighty justification, and therefore tended against dismissal of even very stale claims. And third, the test did not recognise and therefore did not give sufficient weight to the fact that lapse of time alone is harmful to the administration of justice. And he continues, and should be a sufficient basis in itself for the dismissal of proceedings. So you can see here a crucial and significant stepping away from primor. Litigation isn't a two-party operation, and the focus is switching away from things like prejudice and back onto the delay itself. Responding to those weaknesses, he said that little weight should be given to the idea that a dismissal for culpable delay is an interference with a right of access to the courts. He notes that the right of access to the courts is a right to litigate claims. It's not a right simply to institute and perhaps to institutionalize a claim by getting a record number for it. It's a right to get access to justice, but to prosecute your claim. And he said that the law should recognize the fact that passage of time is important in and of itself and can justify dismissal of a claim. So again, you see that emphasis on the passage of time alone. And it seems to me, importantly, given that we have 4 judgments and 2 judgments in the majority, and that the approach taken is a synthesis, it might be said, of the judgments of Mr. Justice Hogan and Mr. Justice Murray. The Chief Justice is very clear at paragraph 34 of his judgment, where he says the approach to be applied henceforth is that set out at paragraphs 26.1 to 26.4 of his own judgment. And there, what he does essentially is he engages in a periodization of the inactivity. So there's a gradated response depending on the level of the plaintiff's or the duration cumulatively of the plaintiff's inactivity. And he says, first of all, that, and this I think is going to be the passage that we will all become very familiar with. First of all, until the point is reached where there has been inactivity for 2 years, a claim should only be dismissed if the claim is an abuse of the process or there is prejudice to the defendant at the level required to ground an application under the O'Donnell and Merrick jurisdiction. The next rung on the ladder then is, after 2 years of total inactivity, a claim may be dismissed for want of prosecution. It is likely that a claim will only be dismissed at this point if, in addition to the period of inactivity, a defendant can point to some additional prejudice or other factor pointing towards a dismissal. If a court does not dismiss the claim, it would be entitled to make strict case management directions on the basis that non-compliance with such directions would itself justify a dismissal. So, bringing practice in the lists generally into line with practice in the commercial list as it stands at the moment. The third rung then, if there has been 4 years of total inactivity, then the claim should be dismissed if it is dependent on oral evidence, so that the defendant is exposed to the risk of failing recollections and witness reluctance that inevitably accompanies a long effluxion of time, unless the plaintiff persuades the court that there are compelling reasons why the claim should not be dismissed and can properly be allowed to go to trial. Conversely, if there are such factors such as specific prejudice to the defendant, that will strengthen the case for dismissal. But it should be emphasized that this is not, it is not necessary to point to any such factor. Passage of this amount of time, that's 4 years plus, is itself enough, and the plaintiff should bear the onus of establishing that there are reasons that the case can properly proceed. And the final gradation, finally, where there has been a cumulative period of complete inactivity for more than 5 years, the court should feel free to dismiss the proceedings unless satisfied that there is a pressing exigency of justice that requires the case to be permitted to go to trial. This would include exceptional situations in which the plaintiff faced educational or social or economic disadvantage, or otherwise in progressing their action in very unusual cases in the realm of public law, where proceedings disclose an issue the public interest demands should be litigated to conclusion, or where there has been serious misconduct by the defendant in the course of the proceedings. And he goes on to agree with Mr. Justice Murray, where Mr. Justice Murray says in his judgment that those kinds of exceptions will be few and far between. So this isn't a place that a plaintiff can hope to get much succour. And that's after complete inactivity of more than 5 years. In relation to complete inactivity, I should say that while Section Order 122 focuses on procedural steps in the proceedings, the court here is concerned with activity by the plaintiff, so that if the plaintiff can come out on affidavit and demonstrate that they were, for example, considering a voluminous discovery, or they were engaging with counsel or engaging with experts, though not taking any steps in the litigation, that would be counted as activity in relation to the inherent jurisdiction. I should just clarify that. Now, to go on then to the judgment of Mr. Justice Hogan, again, in emphasis really of the approach taken by the Chief Justice, he says that it is necessarily implicit in Article 34(1) of the Constitution that the courts have a duty to ensure that the administration of justice operates in an efficient and effective manner. This in turn means that they must be necessarily clothed with the powers designed to make that jurisdiction effective and to protect the administration of justice against abuse. And so it's interesting here that I note this just in passing, that Mr. Justice Hogan roots this inherent power ultimately in the court's power to prevent abuse. That is something that may develop over time as tolerance of delay falls further, and particular conduct in litigation, for example, the warehousing of claims by the beginning of proceedings and then simply taking no action just to keep them there on an in-case basis, absent any formal standstill agreement. That kind of thing has been identified in this case, in the judgment of Mr. Justice Collins, as an abusive process. So abuse is potentially an ingredient in these applications in future. And he goes on to talk about, to confirm, contrary to Mr. Justice Murray's view, that the court does have an inherent jurisdiction to strike out proceedings, so that we're not concerned with the conditionality imposed by Order 122, Rule 11. Now, just to note briefly features of the new approach. First of all, as just noted, the High Court enjoys an inherent power to dismiss for culpable delay. Secondly, the focus is now on the simple lapse of time, which is in principle enough to permit dismissal. The 2-year period identified in Order 122 is the principal yardstick for delay, and that's confirmed by Mr. Justice Hogan and Mr. Justice Murray. The concern is with cumulative inactivity of the plaintiff. That means that scope for considerable delay remains, because cumulative inactivity of, say, 2 years, it may be common, but it's still a very lengthy period of cumulative inactivity. Now, in measuring inactivity, Mr. Justice Murray cautions that the focus is on whether the case as a whole is being prosecuted, so that the court should be concerned only with what he calls a conspectus examination of relatively substantial periods in which nothing is being done to move the case along. And he says that chunks of inactivity of less than 6 months should usually be ignored. So there's a rule of reason in relation to the measurement of inactivity. And finally, in relation to the periods of delay, cases permitted to continue after 5 years of cumulative inactivity will be few and far between. So with that, then, we have a new forensic tool in the periodization of the delay from 0 to 2 years, 2 to 4 years, 4 to 5 years, and over 5 years, as detailed at paragraph 26 of the Chief Justice's judgment. Both the Chief Justice and Mr. Justice Murray, however, caution that it's not a mechanical or mathematical test, and that there will be room for different views in different judges in marginal cases. And I suggest also that there could be unusual circumstances. One that I had to deal with recently involved a counterclaim in a case where the case was, it seemed to me, certainly going to be struck out under either the Primor or the Kirwan terms, but the counterclaim, because it was based essentially on the same row, changed things. And I think that would continue to be the case under the new Kirwan power. There's a focus now primarily, as I say, on the passage of time, but additional prejudice, that is prejudice to be inferred, prejudice beyond that to be inferred from the mere passage of time, remains relevant, but it's become something of a subordinate consideration. Obviously, its primary relevance is in that period between 2 and 4 years, and maybe after 4 years, where it's a documents case, up to 5 years. After the 5th anniversary, really, the approach being suggested by the Supreme Court is that a court shouldn't spend very long at all assessing the thing and should be inclined to dismiss. Next, it's clear now that it's not a defendant's job to move the proceedings along, and the defendant's conduct remains relevant only insofar as it rises to acquiescence or encouragement of the plaintiff's inactivity. So we now have clarity in relation to that issue. Next, the burdens of proof are now reallocated, as you'd have seen in as I went through the 4 different gradations. So the plaintiff now bears a much greater burden of demonstrating why a case should be allowed to continue, and to present and justify and support the excuses that it wants to rely on. In conclusion, then, this case involves what Mr. Justice Hogan describes, first of all, as a modified Primor, though he does say that it is a significant shift from Primor. Mr. Justice Murray speaks of the demise of Primor not being in doubt, and Mr. Justice Collins talks about today, the day of judgment, marking Primor's demise. So, and I think that's probably fair, given the significant shift, to put it at its lowest, away from the approach taken in Primor. So that's my formal presentation. I think it's just I was asked to give 10 minutes or so, but I have more time if that's needed to address questions, so I'd be happy to do that, and thank you all for your attention.
Thanks, Garvan. Yeah, any questions, please put in the chat facility. We've got one question from Declan Devereux. Thank you very much. So, Garvan, what warning, if any, to plaintiff is required, and should defendant query what activity is being undertaken by plaintiff in the absence of procedural step?
There's no warning is required from a defendant. It wouldn't make sense, it seems to me, for a defendant, before bringing an application, to make inquiry as to what the plaintiff is actually engaged in, because if the plaintiff comes up with a good explanation as to what they're doing in the proceedings, that is likely to weigh. It's not necessarily going to be determinative, but it will obviously affect the measurement of the periods of complete inactivity. That said, though, I mean, the plaintiff, it seems to me, can't take all the time in the world to engage in particular steps, though inevitably there will be some sympathy, I think, for plaintiffs who are represented by smaller solicitors' practices, they may be given a wider margin of appreciation in relation to the length of time being taken, for example, to review discovery or the like. But those will become debates. But it would seem to me that now that the question is about complete inactivity, that might well make sense to inquire into exactly what the plaintiff has been doing. Not universally, I suspect, because it's going to be plain in certain circumstances that absolutely nothing is going on, that there couldn't have been anything going on, if you like.
Okay, thank you. So we got another, thanks for the question, Declan. We've got another question from Donald. Donald, can you give some examples of acquiescence by defendant which may be used by a plaintiff in defending a motion to dismiss now after Kirwan? Hopefully that makes sense with my explanation.
Yeah. So acquiescence by a defendant is essentially it's often talked about in terms of estoppel, and so estoppel involves some form of representation being made by the defendant and reliance being placed on that by the plaintiff. I had a case some time ago in which this was raised by a plaintiff, where they said, oh, well, our case was on all fours in relation to the statute with another case that was pending before the courts. And so we stood still awaiting the judgment, and the defendant acquiesced in that. Now, in fact, that was entirely unfounded because the defendant hadn't acquiesced in that. But if the defendant had said, yes, it makes sense to wait for judgment in this other case in order that we can achieve greater clarity on where these proceedings are going, that would amount to acquiescence. So some form of communication or conduct that is such as to give the plaintiff assurance that complaint won't be made in relation to a particular instance of inaction is the kind of thing that I think will give rise to inactivity, or sorry, to acquiescence. But there must be some, it seems to me, some positive step from the defendant in that regard.
Thanks, Garvan. I've got a question on, it's come through on email. So Peter has asked, the judgments referred to the desirability of a change in the rules of the court. What changes are envisaged?
Well, I suspect that the Rules Committee, when it goes to look at this, is going to turn to paragraph 26 of the Chief Justice's decision, and that it will attempt to craft rules that reflect that approach. I have to say that, you know, it remains to be seen whether ultimately this decision will cut the Gordian knot, or whether it will just give rise to a whole range of new debates around what is inactivity and that kind of thing, the kind of things that have come up in the questions already, whether there's been inactivity, whether there's been acquiescence and so forth. Because obviously these are high stakes applications for plaintiffs and defendants. So, but that I think is probably the course that the direction that the Rules Committee would look in the first instance. I suspect, though, that the question of delay in litigation is really going to be with us for until we have more advanced forms of case management in the lists other than the commercial list. That is the thing that really excludes the possibility of delay in truth, it seems to me.
Right, and I've got so Brian's got his hand up here. I'm going to see if I can unmute you, Brian.
Wondering, is any account taken of pre-proceeding delay? In other words, somebody waiting perhaps for 6 years, 5 years and 11 months and X days. Is any account taken of that in what seems to be a measurement by the court, if I'm understanding correctly, of post-commencement of proceedings.
I think you're right, Brian. I think that the court is talking about post-commencement proceedings, but the the existing position, long-standing position in relation to pre-commencement delay, I think will continue to apply, where it's said that if a plaintiff delays in beginning, they have an additional duty to get on with it at pace. So I think that will remain an influential factor. And of course, it will give extra weight to a defendant in saying, look, the prejudice that arises by reason of passage of time is more significant in this case. So it will remain a factor, I think, but in much the same way as it's a factor today, I suspect.
Thank you very much.
Okay, thank you. So that's seems to be all the questions. So thanks, Garvan, and thanks for all those questions. So it just really leaves it for me to say a very big thank you to Garvan for your time today and that interesting in-depth presentation today as well. I will send around to everybody who attended Garvan's PowerPoint presentation, so that will probably come over to you tomorrow now. And we will also, in due course, send over your CPT certificate as well. But apart from that, thank you, everybody, for attending today. And again, big thank you to Garvan today. So thank you, everyone.
You're welcome. Thanks very much, everyone.
Goodbye.